Sims.
Here.
All right, and before we get started, we need to elect a vice chair. I recommend Don. If he's willing to do it.
I'll do it.
Thank you, Don, for stepping up. All in favor of Don?
All right.
It's unanimous.
That's because nobody else wants it.
It's the one person who wasn't paying attention. You gotta-
That was it, yeah. Took a lunch break, and there you go.
Usually we elect the one who's not here.
It's been there.
We're gonna review are we doing this in order on the agenda?
Yes.
Correct.
So we're gonna review the following comprehensive plan amendment relating to the water supply plan. An ordinance of the City of Bonita Springs, Florida, providing for adoption of a comprehensive plan amendment relating to the water supply plan of the infrastructure and capital improvement elements, providing for intent, providing for severability, and providing for an effective date.
Actually, Mr. Chairman, before we really get going in this one, if it's okay with you, we might want to think about reversing the order of this. We have several consultants here for the other plan, and that might be something we want to do first, so.
That works.
Let's do that. So who wants to be up first?
Chairman, can you move your mic a little bit closer? I think we're,
Sorry.
okay.
Move.
Yeah.
We're good.
As we get going on this, Mr. Mayor, just a little framework as to where we're going on it. Just so everybody knows, this comprehensive plan amendment is naturally reviewed under the standards of Florida statute, but it's also been reviewed under the framework of a settlement the city has with property owners and to settle some litigation between the two. And so what you're looking at is a little of a modified review from what you normally see. So when we're going forward with this, just a heads up, there are some things here that either are not included or are included that you normally wouldn't see in a review or wouldn't be included in your packet. So if those come up, we'll identify them later on.
All right, so we're going to proceed. Who's our first speaker?
David Depew. He's been accepted as an expert in comprehensive planning
Okay.
before the city before.
All right, thanks for being here, sir.
Thank you for having me. As Ms. Montgomery said, my name is David Depew. I am principal with the firm of Morris Depew Associates and a planner. What you have before you today is a comprehensive plan amendment. As the indication there is actually two, CPA 19-66379-BOS and CPA 19-66165-BOS. One is a map amendment, one is a text amendment. We also have had a consultant team working on this for quite some time. I'm not going to go through all those, but let me just tell you it's a group of well-known professionals that have been involved in the various elements of both of these comprehensive plan amendments. You may see the property. I think everyone is aware of the Bonita Grand Mine. It's in the extreme northeast corner of the city. And you will see on the slide there the actual property itself. And to the north, which is not really shown on there, is Lee County, and it's the Edison Farms property. To the east is the Crew lands. To the west is Belle Villa, Citrus Park, BSU, and you can actually see I-75 as it cuts down through the center of the slide. On the lower end of the slide, you can see Bonita Beach Road, and then you see Bonita Grand Drive going up towards the mine itself. And East Terry Street is located just south of the mine. Surrounding designations for the future land use map in this area include Lee County's DRGR to the north, and on this, the slide is twisted around so that north is to the left. You can see the DRGR on the north, which is the Edison Farms property. It's vacant, undeveloped land. On the east is the Crew property, again, vacant, undeveloped land. The mine property is there in the center, and you can see the excavation areas. We have the City of Bonita Springs DRGR property located to the west of the subject property, and a variety of different uses, including agricultural grove activity as well as residential uses and a recreational vehicle park To the south, you can see areas of the city of Bonita Springs that are located in vacant and residential and agricultural uses, and there are parts of that, again, in DRGR as well as in preservation. Surrounding zoning categories include agriculture and mobile home zoning. You can see the green of the agricultural zoning and the light brown of the mobile home zoning to the southwest of the subject property. Subject property itself is zoned as an industrial planned development. The property has a long and historic background. The mine site itself is 1,268 acres in size, of which there are 370 acres currently designated for conservation and under conservation easement at the moment. There are just under 700 acres of mine lakes approved for the property at the moment, and just under 400 acres actually excavated. You can see the excavation and the configuration of the mine itself there on the left-hand part of the slide. The amendment, however, encompasses an additional 75 acres of farmland that is directly to the south of the mine and is currently in the DRGR of the city. Current future land use designation of the mine remains Lee County's density reduction, groundwater resource, and wetlands, as those categories were defined in 2003 when the annexation actually took place. There's been no change in the property since 2003. So for over 16 years, the city has left the county's DRGR designation on the property. The DRGR category allows natural resource extraction, which is to say mining, as a permissible use. Mining on the subject property was first approved in 1987 on the southern portion of the site. In 1998, Resolution Z98-071 was approved by the county and extended the mine footprint up to the northerly portion of the site. Resolution Z-02-047 permitted the current operation to a depth of 90 feet, or the confining layer, whichever comes first. The settlement agreement, which this is here before you today as part of the settlement agreement that was reached with the city, extends the date for mining to December 31st, 2041. That has been approved as part of the industrial plan development zoning that was heard by the city council last month. The environmental permits covering stormwater management, wetland preservation, and reclamation are in place, and those were first issued by FDEP in 1991 and will also expire in 2041. Mine was annexed into the city in 2003 pursuant to an annexation agreement that was ultimately adopted in February of 2003. And in 2003, late 2003, the city also recognized that mining and the associated uses are vested and permitted to continue. In spite of the language of the annexation agreement, along with at least 3 separate sets of recommendations for plan amendments the city has not adopted for the last 16 years, future land use amendments to cover the mine, and that is what is here for you today to consider. There have also been 2 prior requests from the property owners to amend the future land use, consistent with the studies that had been undertaken at the time of the application. The last request resulted in the 2013 moratorium and the city's Citizens Water Resources Task Force to come forward with recommendations that were ultimately adopted in 2014 by the City Council. Today before you is the 3rd set of amendments requested on the part of the mine owners and under the provisions of the settlement agreement between the mine and the city, and it is for that reason the LPA is being asked to evaluate the application. For the members of the LPA that have not had the opportunity to review the past studies that looked into the city's DRGR area, let me simply summarize the findings with regard to the subject property. In every instance, so long as best management practices were agreed to for any development plan, the recommended densities for development were higher than that which is before you today. As I said, this is a part of a request that has other elements to it. And this this part that's before you today represents two critical elements that have been agreed upon between the city and the mine, the text amendment and the map amendment. Together, these two amendments will bring the mine property fully into the city and under the city's comprehensive plan and land development regulations. The amendments provide for provisions of that designation and then providing for change in the future land use map to apply that category to the mine and an adjacent parcel under the same ownership. This is a total of 1,348 acres of property, so that's over 2 square miles. The language of the conservation fringe category establishes the maximum density proposed to the subject property. It establishes the acreage designated for residential development and the areas for public open space as well as preservation. And subsequent to the adoption of the plan amendments, a rezoning request will be filed to change the property zoning category from IPD to RPD, residential plan development. Current request is intended to not only implement the settlement agreement resolving 6 separate lawsuits, but also to transition the existing and proposed reclamation uses from the county comprehensive plan to the city's comprehensive plan. And this is what was envisioned when the annexation actually occurred by all parties in 2003. Now, this is the language without the design criteria of the conservation fringe. I'm not going to try and read all of that. I'm assuming that the LPA has gone through their packet and read all of the information, but I do want to highlight a couple things. The category has to include an existing vested mine, of which the subject property is the only one in the city of Bonita Springs. Additionally, I would note that it's adjacent to lands with significant environmental resource and habitat values. Again, this is a unique attribute of the subject property. Policy indicates that reclamation will be done in a fashion that is compatible with adjacent environmentally sensitive lands, and land uses are limited to conservation, existing vested mines, agriculture, residential, and residential accessory uses with a density of no greater than 0.522 units per acre. And this is done on a gross acreage calculation, along with essential services and public recreational uses. Calculation of gross density is done for the entirety of the property, although the units are clustered on the upland areas or the disturbed lands in accordance with the policy. Certain amount of contiguous property under common ownership is to be included in the overall total for residential purposes, and the total number of residential units for the category may not exceed 700 dwelling units. This is on over 2 sections of land, so we're looking at 0.522 units per acre gross. Comprehensive Plan Amendment is also inclusive of a map amendment, and it is being requested to bring this into the city future land use category. Proposed plan amendment will facilitate redevelopment of the existing mine site to a low-density residential subdivision clustered on the upland and the disturbed areas of the property. The annexation agreement makes it clear that the property was annexed by the city to provide for a future land use designation of the property that would be consistent with the studies undertaken by the city that recognize the various benefits of redevelopment of the subject property. Studies previously undertaken by the city found it appropriate to reclassify the subject property, and this map amendment, along with the accompanying text amendment, will actually accomplish that. The proposed amendments will not affect the conservation and preservation uses found on the property. The text amendment was crafted to be uniquely applicable to the subject property and its characteristics, and right now it's the only piece of property in the city that could qualify for this particular land use designation. It includes the requirement that the property be vested for mining operations, as well as the fact that the crew and 2020 preservation lands to the southeast, east, and north will be buffered and set aside as uses that are going to be preserved in the future. The maximum density under the conservation fringe category is 0.522 units per acre, not more than 700 total dwelling units on the 1,343 acres. The text amendment also establishes design criteria intended to address specific conditions on the subject property, as well as interconnections between the subject property and the physical conditions that surround the subject property. These are the various design criteria, performance and design criteria. I'm not going to try and go through all of them, Let me simply highlight a couple of the design criteria. First off, it has to be rezoned as a planned development, allowing for certain criteria to be established as part of the zoning request. Restoration and accommodation of historic and existing regional flowways has got to be part of the design, along with the restoration and accommodation of existing and historic groundwater levels. This site has been the subject of significant studies regarding groundwater, regarding hydrology, regarding surface water management. It currently retains all of its stormwater management on site, and the intention is ultimately to continue to retain all of the stormwater management on the site in its redeveloped and reclaimed situation. One of the provisions includes critical wildlife connections and indigenous upland habitats being preserved and restored, and enhanced lake management plans and provision of erosion control and lake bank stabilization, establishment of education programs for any homeowners in the future regarding restricted lake uses, fertilizer use, pesticide use, and very site-specific ecological elements as part of the ultimate design. Conservation easements for every preservation area. It will be platted as a part of the master plat for the property and dedicated to appropriate maintenance entity. Text amendment includes the requirement for use of Florida-friendly plantings with low irrigation requirements, retainage of not just the stormwater on the site, but a minimum of 1.5 inches of water quality treatment, and an additional 0.05 inches of runoff for the developed area. Existing vested mining uses would be eliminated as an appropriate phasing plan and schedule that would be part of the planned development. On and off-site improvements for the transportation infrastructure needed to mitigate traffic impacts of the planned development would be provided, subject to any prior agreements, and improvements on the road system would include low-impact roadway design, linear filter marsh, retention elements, and other green roadway design features. Utilities would be connected to Bonita Springs utilities at the cost of the developer, and other uses would be available as demonstrated by the ability of the various agencies to perform those uses, things like the school district and the emergency medical service and the fire district, the sheriff's office. Finally, golf course use would be prohibited. This is what it looks like in one of the most recent aerial photographs. The areas that are the kind of milkier colored of the lakes are the ones where activities have been taking place in this particular photograph. And so you can see there's been excavation on the very north end and then on the southwest corner of the site in this particular photograph, whereas the other lakes in the center and in the southeast portion of the site have not been excavated as recently. That's simply because of the sediment load that's in the lakes, and that's what happens as part of the excavation. We took a look at Lee Plan consistency, since it's still as part of the Lee Plan under its current designation. And Lee County, in fact, there was an article just in yesterday's paper about reclamation of a very large agricultural operation off of Corkscrew Road. But Lee County has looked at very successfully changing and modifying, reclaiming these old excavation areas. And you see before you two of the examples that I'm personally familiar with, Corkscrew Shores and Wild Blue, in which these are both excavation lakes that have been done through the 80s and 90s that are now turned into very vibrant and active residential communities, lakefront residential communities. And they're lovely communities, and they can show you what exactly we're looking at for something like this. It's a beautiful waterfront community that is taking place and being created in Wild Blue and has been created at Corkscrew Shores. So reclamation of mine lakes is not something new. We know how to do it. We've been doing it for quite some time, and it looks like this is a prime candidate for that. As long as I've been working on this, which has been through the last 25 or so, 30 years, It's always been the intent of the owners to reclaim this into a vibrant residential community that looks similar to the ones that you see before you on the slides. Reclamation of agricultural properties with density bonus has also been determined to be consistent with the environmental values that have been espoused in the county's plan. In terms of the city's comprehensive plan, we believe that the proposed amendments are going to establish an ecologically sound basis for reclamation of the property, that it's consistent with the protection of natural resources on the property as well as in the area. While the current reclamation plans are consistent with the state requirements, they do not address the long-term and continuing protection of water resources and other environmental goals, objectives, and policies that are found in the city's comprehensive plan. The proposed amendments will change that and apply the design criteria to the reclamation and eventual development of the site and turn that into a long-term, environmentally reasonable and responsible property. Conservation fringe land use seeks to promote redevelopment of the property in a way that incorporates the existing or historic natural systems and promotes design flexibility, encouraging pedestrian connectivity, complete streets, and greenways. These elements must be incorporated into the design and approved conceptual plans of the required plan development rezoning to ensure consistency with the city's comprehensive plan vision. The DRGR future land use on the subject property is a carryover category from Lee County. Proposed amendment would establish the conservation fringe future land use to acknowledge the subject property existing mining use, establish a timeline for the completion of mining activities, and promote redevelopment of the property to a low-density residential community. The proposed amendment would eliminate the alleged inconsistency of the property's existing use consistent with Objective 1.4 and supporting Policy 1.4.1. Amendments are consistent with policies already found in the city plan, provide incentives for responsible development sensitive to environmentally critical areas. Consistent with the policies in the in the coastal conservation management element, the amendments seek to manage wetland and upland systems to enhance native habitats, species diversity, water quality, and natural surface water characteristics while protecting these features from impacts of future development. Additionally, part of the settlement agreement establishes recreational uses on the northerly portion of the site in order to provide additional opportunities for public access. Proposed future land use map amendment will enable the city to keep pace with projected population increase, providing additional housing opportunities while promoting a clustered form of development, preservation of native habitat, connection to central water and sanitary sewer systems, and enhanced protection of natural resources. The data and analysis supporting the proposed amendments include, but is not limited to, the raw report from 2005, the 2009 DeLisi Fitzgerald analysis, the 2013 Baracco report, the City of Bonita Springs Citizens Water Quality Task Force report from 2014, most recent population estimates and projections from OEDR, groundwater and hydrological and geological reports submitted as part of the application materials, traffic analysis that have been submitted as part of the application materials, the Lower West Coast water supply plan from the Water Management District, various impact analyses and service availability materials submitted as part of the application, ecological studies and reports that have been submitted as part of the application and are on file from years of the activity that has taken place with the mine, the existing permits that have been submitted as part of the application materials, the testimony and exhibits that have been submitted as part of the overall application and the hearing itself. All of these materials, I believe, demonstrate that the proposed amendment seeks to implement the provisions of both the statutes and the City of Bonita Springs comprehensive plan. The amendments discourage urban sprawl by directing growth in a manner that will protect natural resources, promote efficient extension of infrastructure, conserve water and energy, preserve open space, and provide recreational opportunities, provide for an innovative development pattern that will reclaim the existing mining lake. In terms of the Citizens Water Quality Strategy Task Force, we believe that the ultimate design of the residential plan development will implement Water Quantity Recommendation 1, Water Quantity Recommendation 4, Water Quantity Recommendation 10, Water Quantity Recommendation 13, 18, And water quality recommendation 3, 4, 6. Water supply and drinking water recommendation number 1, number 2, and number 3. I can go into those in more detail, but I assure you, you really don't want me to do that.
I would beg you not to.
Based upon the applications, the exhibits, the testimony, it's my professional opinion that the Bonita Grand Mine LLC has made a proper application for these amendments to the city's comprehensive plan, has met all of the applicable goals, objectives, and policies, is consistent with the statutory requirements found in Chapter 163, Part 2 of the Florida statutes, and meets generally accepted planning principles. It's also my professional opinion that the application and testimony have provided the necessary record that entitles the request to a recommendation of approval from the LPA to the City Council. Finally, it's my professional opinion that the proposed amendments properly seek, as currently proposed, to implement a portion of the settlement agreement reached between BG Mine LLC and the City of Bonita Springs. I am happy to answer questions. That completes the formal presentation part.
I have a question.
Yes, sir.
My understanding is this is, the mine area is, this ordinance is specific to that area. Yet I noticed on page 15, where it outlines the conservation fringe, the first allowable land use is agriculture is listed there. And so I'm wondering if this could be used other places in the DRGR under the agriculture classification.
It cannot, because the requirements of the definition include that a vested mining operation has to be part of the current land use on the site, and if it's an agricultural use, it has to be adjacent to the existing vested mining operation up to a maximum of 10% of that property. So the only one that actually can meet that under the current situation is this little piece of property right just to the south there that has been included as part of the overall map amendment.
Okay, this is not an avenue to open up the DRGR.
It is not, no, sir.
Okay, the other question, while we're on that area right there, part of this extends into a well protection area, does it not?
There are well field protection zones in this area. I don't have that map. It's well outside of anything greater than the 10-year travel time.
Okay, but nothing here that we would be doing would be exceeding the protections from the well protection area?
No, sir. And that's part of the requirement of the design criteria that water
very
quality and quantity has to.
And then the other quick question, or not question, but back on the traffic study, back on page 140, I noticed that it does not, in the traffic analysis, it does not include Logan, and yet Logan will be there a long time before any houses are there. I just wonder why an important connection like Logan would not be part of your traffic study.
I believe because we didn't trip the levels of significance on Logan. In terms of the traffic that was going to go there, there has to be a certain level of significance before it hits the analysis, the stage
Okay.
for analysis.
That's
Good, thank you. Anybody else?
Just a couple. It does state in here that there will be no golf course there.
Yes, sir.
Period.
Yes, sir.
End of statement. Okay.
Yes, sir. To amend that, we'd have to come back before you and say, we'd like to take that provision out. It's specifically in there saying no golf course.
My other question is, there are neighboring properties to that little piece that's out there off of Bonita Grand. Those will not be affected zoning-wise by whatever they have is theirs.
Yes, sir.
I do have some friends that live out there.
The question I might have has to do with development and why you would need an amendment change, to the comp plan. What we're talking about here is development, RPG, residential plan development. So what we're looking at is we're developing the land that the BG mine owns, right?
Yes, sir.
Now, at one time, that land was considered part of the DRGR and not to be developed, right, when they first bought the property.
No, sir, when the first mine started, there was no DRGR.
Okay?
This-
Now, when the
Well,
DR
this predated DRGR.
when the DRGR came up, that was to protect the groundwater and protect the wildlife and so forth in there. But they bought the property prior to that,
Yes, sir,
so they were not buying into it knowing that that was existing.
that's correct.
So why did the DRGR come up that included their land?
Well, that's an interesting question, and I'm not sure I can give you in any kind of a reasonable length of time the history of how the DRGR came up and why that property was included in it.
Well, but let's talk about two things, and I think Dave can answer these that hopefully will help you. One is, at the time when the DRGR was created, there was a rule called 9J5.
Correct.
And 9J5 was a rule that said you had to show need. And then Secretary Pelham of the Department of Community Affairs said, and this was back in the 90s, I know Dave knows the date, that the county's overall map accommodated too much population.
Actually, this was 1991.
But since that time, I think in 2011, that need requirement was removed. Is that correct?
Yes, that's correct.
And the other thing is you talked about the groundwater resource, and at the time, the county was concerned that they didn't know where their future water supply was going to come from. There was no study. So one of the then planners, Bill Spakowski, said, well, Wayne Daltrey, we've got to save everything because we don't know where the water supply is going to come from. I noticed on your agenda that you're going to adopt the Water Management District's water supply plan. So, Dave, let me ask you, since the DRGR was created, did the legislature change the rules and require a linkage between planning and water supply plans? And is the local government supposed to rely on the Water Management District's water supply plan?
Yes, ma'am, and that's really a part of the answer. I mean, and the DRGR, the implementation of DRGR and why this property was put in it, it goes back to that needs analysis. It was a calculation of potential population density. I mean, you might as well ask, why was Citrus Park included in DRGR? They don't meet any of the criteria of DRGR. So, part of the answer is political. They had no one representing their interests that pushed hard enough, and part of the answer is bureaucratic in some sense, in that they needed the planners needed a large area to calculate the lower density off of. So I mean, it's a complicated answer to your question.
Yeah, I mean, I don't know, maybe you can see where I'm going with this, is that Bonita has very little land to develop. Now, the mine wants to get into the development business, basically, because they're developing, 700 houses out there. This also ties in with, you can't develop houses without water. That ties into the other amendment we're looking at today. And so, but I think the court ruled recently that the mine company can develop whatever they want to. Is that correct? They can do this. They can put the 700 houses in there.
No, this is a settlement agreement between the.
But they can move forward with that plan to develop those houses.
That is the proposal.
And that proposal, so it's not been determined yet.
No, the land use changes that are under consideration now would be required before that could be effectuated. But I can give you a little bit more of the background, Mr. Vincent. This property was classified as DRGR when the property was still under the jurisdiction of the county. After that, which time the property owners, or we're not the current property owners, but the previous property owners brought the property and an annexation agreement to the city to annex the property into the city under the specific request that the city would consider changing the land use. Now, the city has a statutory obligation to change the land use to a city designation. It meant well over a decade without either the city adopting one or completing all the requirements to do that. And that was the nature of the litigation. So at some point, the city has to take action on this property. This is part of the settlement that resolves it. At this point, it's, you know, we are looking at this as appropriate for limited development. And that's what the proposal.
So the city is looking for 700 more houses, right? Basically.
The city is willing to consider 700 more houses.
Now,
It's
as I
not
understand
imposing.
that all of the infrastructure, so forth, is to be paid for by the city.
No.
What infrastructure are you referring to?
Roads,
No. Road is not,
Paying
the
for
city
roads?
is not paying for any
the
roads.
connection to Terry Street is not going to be paid by the city to get to the
No, sir.
mine property?
That's a private road right now.
Okay, so that will be improved to handle the traffic
It will.
by who? The land, the
By the
developer?
developer, for the landowner.
Okay.
Yes, sir. As well as the extension of water and sewer, and ultimately, if available, reuse irrigation.
Sam, the reason why the mine was outside the city limits is when we incorporated the city, we had to draw a line someplace. And at that time, we were going to go quite a bit further out beyond Bonita Grand with the city limit, eastern city limits. We wanted to have at least 1,000 feet off of east of Bonita Grand and 1,000 feet north of Bonita Beach Road. But at the time we incorporated the city, there was a requirement by the state that there had to be a certain population per acre. And if we incorporated all that bare land out there, we could not take in Black Island and the area that we took in out on the coast, which we thought was more important than the bare land out there. So we arbitrarily, because the fire district had a map with a legal description on it, we went up Bonita Grand, and everything on the east side of Bonita Grand was outside the city. But it was just a line drawn on a piece of paper back when we incorporated. That's how it happened.
So you need an amendment change here in the comp plan to agree to develop it, right? It would sort of increase the coverage of the comp plan to cover this portion. I don't understand why you need a change in the comp plan. Maybe you can tell me that.
Sure. The current DRGR won't allow the redevelopment of this property in a fashion that will reclaim it consistent with the city's long-term goals. We can stick with what's there right now and reclaim it in accordance with our FDEP permits. But the city's not going to get their park on the north side of the property. The city's not going to get the kind of environmental improvements to this property and reclamation elements of this property that the city plan wants, but that FDEP it's not part of their reclamation permits that have already been granted on this property. So this is a win-win, I think, for both. And it allows, the development allows the developer to finance the kinds of improvements to this property that are going to turn it into what I showed you there at Corkscrew Shores, as opposed to simply leaving it as a hole in the ground with the side slopes kind of redone. I mean, we're going to have to bring in soil in order to enhance the ability of the ground to support vegetation. We're going to have to create low-impact development stormwater management systems that are going to be grassed swales on this property to handle the runoff. We're going to have to enhance the upland as well as the wetland areas and maintain them long-term over time. I mean, there's lots of various pluses to this that we think are going to make this property really a vibrant part of the community.
So what comes first, the development of the 700 houses or the improvement to this land that the city wants?
It's going to come at the same time. They're
All
coincidental.
this happens at the same time.
Correct.
So as you say, and that's kind of what I was looking for, was the win-win here of what the city how the city benefits by this. Now, the mine still maintains the lakes, right, for their operation?
Well, ultimately, those lakes get turned over to the Property Owners Association, and the property owners will maintain the lakes.
The 700 houses in there.
Correct, yes, sir.
So they determine what they want to do with that. And when that happens, BG Mines does the work for them?
As part of the reclamation plan, the owners will reclaim the property and establish all of the green features that are going to be part of that development.
Well, and another example I think that Mr. Depew is familiar with, and I know you guys all are, is the property where Miramar Lakes and FGCU was in the DRGR, was taken out of the DRGR. The county had wanted to reclaim the Stewart Cypress Slough, but didn't have the money because it's incredibly expensive to do that. And as part of those developments, the Stewart Cypress Slough got reclaimed, water got redirected to the place it was supposed to go, and those lakes got reclaimed.
That was actually also part of the Wild Blue development that worked with Miramar Lakes and with FGCU to preserve the Stewart Slough through that property. That was larger than a 3,000 acre tract that we ultimately reclaimed in that fashion.
So according to the agreement, the mine must do this work. They
Yes,
can't
sir.
just bail out at any time.
Yes, sir.
And one of the things, and Dave can attest to this, but the Lee County DRGR is policy 1.4.5. And what that says is these are areas most suitable for future, well fields, that you're going to actually use them for well fields. And I think Dave was there when the commission adopted that category, and what they said was, and if you don't meet that requirement, just come in and we'll take you out.
Yeah, I mean, the other thing I'd point out is that Lee County Utilities is getting most of their water now from wells that are literally just a couple hundred feet away from these mines. The Green Meadows well field literally goes between two separate mines to the north and to the south, and their wells are just spaced along an upland ridge that goes between these two mines. If you go down to the Youngquist Brothers mine on Lico Road, down by the Corkscrew water treatment plant, there are wells. I mean, when you go into the mine, if you're one of the subcontractors picking up rock, if you go into the mine, you have to drive right by a couple of the wells as you go in, and they're pulling water right out of the ground, literally just a couple hundred feet away from the Youngquist mine. And the last I heard, the water plant was also dumping their calcium chlorides into the pit at the mine. So they were getting rid of some of the refuse from the water treatment process into the excavation area that they were taking the fresh water out of. Now, they've also put water wells all along Corkscrew Road and intercepted some of the water that's coming through subsurface, the drainage areas through there. But I still think that well over 50% of Lee County Utilities' water is coming from wells that are adjacent to these older excavation areas. And there's nothing wrong with doing that. It pulls water from an area that has more water than it had prior to the excavation.
So
And let me ask you a question, Dave, to kind of follow up on that. In the 90s, when the DRGR was created, weren't most of the wells in the superficial aquifer, and after that, the Water Management District encouraged local governments or utilities to go into the deeper aquifers that aren't affected?
Yes, that's true. That's true.
So this land, for these 700 houses there, is not really conducive to mining.
The resource is there. The resource is being mined out, and the area itself can still support the mine, but the owners of the mine have recognized, and actually from 2003 onward, have recognized that the days of the mine are numbered, and it would be nice to change that over. I can assure you that everyone I've talked to from Citrus Park and Bellevilla would be happy if the mine stopped tomorrow. So And Serpy the other day was telling me, get this done, get this done. So,
Thanks for your answer.
Yeah.
That does answer my question.
Don, go ahead.
Just two things. One, I read through this riveting pile here. What is BE 278?
BE 278.
There's obligations of BGM, which we know is Bonita Grand Mine, and BE 278.
Oh, I think that's one of the trusts for the other piece of property, the 75 acres. Is that the name of that? Yeah, that's the other 75 acres just to the south.
Okay. And my other question, comment, whatever you like, he stated that there's no, that the mine property is going to take care of the road from Terry Street into their property.
Yes, sir.
That means the city is going to be responsible for the rest of Bonita Grand out to
You'll,
Bonita Beach Road and Terry Street, which has a 2-lane bridge over I-75.
But this Bonita Grand is a county road. And the city is not making any plans to make improvements on that, as long as it is a county road.
That Terry Street concerns me because you're talking about a bridge over I-75.
and you'll note that in the agreement, it actually talks about, or the design criteria, I got to go back to my notes here, because I don't remember the number of it right off the top of my head. But there's a statement in there that says that they will be responsible for their
Proportionate fair share.
proportionate fair share, right.
To answer the vice chair's question, part of the consideration for the numbers of 700 units is that those roads out there are already on the verge of failing. The city does not wish to increase the capacity on those roads to the point that would require improvements such as 4-laning Terry Street. It's not in the city's vision. The city's vision for those roads are to remain 2-lane, possibly improved through other means, intersection improvements, multi-use paths and otherwise. And so the number of 700 units was designed to keep those traffic impacts to a very minimum so that we would not be triggering those improvements.
Remember, we're getting rid of the trucks. So the trucks are going to go away, and they're going to be replaced by passenger cars. So that's kind of the layman's answer to that.
To sum this up, there's no expectation by BGM on the city to fork over money to make this a reality.
That is correct. Well, when I say that, there's a potential for a payment for the northerly port of the site, I believe.
There are the city will be getting access to the northern lake, an easement across the northern lake for public use, as well as a 30-acre park at what I'll call the trailhead to Edison Farms at the end of the mine property. In addition to that, because the city is not requiring improvements to Bonita Grand or to Terry Street other than the connection and the intersection improvements, we are not charging impact fees for improvements we do not intend to make. So in other words, the original designs for this project, if it had gone at a higher density, would have required the 4-laning of Bonita Grand. It's not the city's desire to do that, and so we're not charging that. We're not being hypocrites, essentially. We're not charging for something we're not intending to do.
Anything else? All right. Thank you very much, sir.
Thank you all.
We're going to move on to any public comments regarding this? No? We'll keep moving. Water usage.
Any staff
We're going to vote on this, yes.
vote, and if there's any staff,
Yeah, any public comment
input.
as well.
Thank you. For the record, Jacqueline Genson. What I just want to let you know is this petition was reviewed by our engineering team, transportation, environmental planning and survey. Staff has no objections to the applicant's analysis regarding the existing zoning, land use, and future land use analysis. We just wanted to put on the record that we do acknowledge the references to all the studies that were commissioned by the city, but City Council never accepted any of those studies. In terms of the staff analysis, that's all included in Attachment A of your staff report. There's 2 separate supplements, if you will. The first one goes into the 163 analysis that's required, so that's 163.3177. This is a legislative action by the city council for them to go ahead and hear this request. And a lot of this is also, staff has received direction by virtue of the settlement agreement to go ahead and process this application. In terms of comments for the LPA, I just wanted to go ahead and let you know there is a wellfield protection map in your packet. So I think, Mr. Calipetro, that was one of your questions. So that's on page, or Rex, I'm sorry, that was one of yours. So that's page 207, if you have any questions on that. In terms of the BE 278, that's identified in your settlement agreement attachment. So that's actually another piece of property. It's not the 25 acres south of the existing mine. That 25 acres is Bonita East 22 LLC. So if there's any other questions on that, we can answer. And other than that, if you'd like for us to go into more detail, most of the information is contained in our staff report attachment A.
Okay, thank you. Let's take a vote on it.
I would make a motion that we adopt this ordinance as presented.
I'll second it.
All in favor?
Aye.
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 We're voting on 4, right?
Yes.
Okay.
Thank you very much.
Thank you.
It's kind of interesting that in 2003, this board set up a special zoning, a new special zoning classification for the lots out there. We, at the time that this came up the first time, we felt that this was a estate. We established a new zoning classification called estate luxury lots or something like that, and it was specifically for this development out there.
Interesting.
So we've come a big circle.
But as it stands right now, the land is just bare? That land is bare out there, where the 700 houses is proposed?
Well, and you probably, some of you I know remember that sections 1, 2, and 3 where Bonita National are, and were in the county GR annexed into the city, and that land use category was changed, and you created a new one. So this isn't the first time the LPA has considered this kind of.
The whole thing was DRGR out there, and when we drew the city lines, what was inside was also DRGR, so if it was inside.
So in the future, we'll take up all of the DRGR for houses, right?
That's where we're going.
It looks like that's where we're going.
All right, we're going to take a look at the comprehensive plan amendment relating to the water supply plan.
Yes,
Let's do it.
let's do it. So again, in lieu of a presentation for you guys, I prepared a brief memo, as well as the attached green sheet. Essentially, what we are doing as staff in coordination with BSU is updating our comprehensive plan to match the requirements spelled out in the Lower West Coast Regional Water Supply Plan done by the Water Management District, as well as BSU data for different well locations, depths, daily usage, annual usage, really just kind of bring into compliance with the statute. So not a whole lot of metrics have changed, not a whole lot of core content has changed. It's been mostly updates of tables and some brief narratives to adjust for things like Citrus Park, for example. If you guys have any questions, feel free to answer them. But in terms of what it is, it's not an overly controversial item. It's just more or less bringing us to consistency with the state requirements.
I have a question.
Go ahead, sir.
And
Hi, Rex.
the nitty-gritty, as I interpret this
Yes, sir.
to the bottom line, is that if the facilities are available adjacent to you, you're required to hook up to it. That's simple enough. But on the last policy, it says where the alternative, that means the gray water, distributions are available, the city shall enforce requirements that no person shall use potable water for irrigation purposes. Okay, I understand that.
Yes, sir.
But the way it is right now, all the reclaimed water is already contracted for. So.
Yes, any effluent the utility provider has.
But in the future, there'll be something different.
Correct, yes, sir.
My question on that last one is, well, how about people who use, for their irrigation system, use their well?
So we don't have metrics for all the individual wells within the Bonita Springs area. Any type of permitting for that would go through either the county, depending on the well depth and type, if it's for potable water consumption, or if it is utilized for actual agricultural operations, or simply irrigation for a single-family home. It could either, again, go to the county for that, or potentially to the district, depending on the level of consumption use, and they would have their own permit requirements for drawdown. Yes, sir.
The water for the 700 houses that are proposed, is that coming from Bonita Springs, the BSU?
Yes, sir. Yes. And that was actually, part of that is calculated and accounted for in some of these metrics. I know that the utility provider is keeping a close eye on that area to kind of see where the city ultimately has that shake out. And if you take a look at some of the metrics in the data, we are actually currently running under a surplus. And based upon population projections, which roughly take that growth into account as a percentage of county overall growth, we should still continue to have a surplus, predicated on BSU getting to do the additional drawdowns and modifications that they already have programmed well into the future. Yes, sir.
Anybody else? Any public comment? Beautiful.
I don't think we have any public.
Yeah, no. It's, and, anybody want to make a motion?
I made the first one, somebody else makes second.
I'll make a motion. We adopt the ordinance.
I second that.
All in favor?
Aye.
Aye.
Thank you very much.
Okay, let's see what we got here.
Next meeting.
Approval
of the minutes.
Approval of minutes from last time.
I didn't get any minutes.
Do we have to read those, or can we just approve them?
You can approve them
Let's go ahead and approve those. All in favor?
unless there are any objections.
Yeah.
There are no objections, so
I'm doing good.
aye.
When is our next meeting?
Do you have a date for next meeting? Oh. I think we do have something set for February. I think we have some items. The 13th of February.
February 13th, thank you. So next meeting is February 13th,
Flores may not be here, but
and we're going to call this meeting adjourned. Thanks, everyone.
Very much.